Right, counsel, where are we on discovery?
So Judge, the complainant in this matter is in CPS custody and actually is hospitalized at this time.
Mhm.
So there's ongoing medical records that will need state regarding the condition of the complainant and how we're best going to go forward in this matter. So we definitely need a reset.
Okay. All right, Ms. Ferguson, give me a 45-day reset for discovery on this case, please.
October 9th.
That's fine, Judge.
All right. Do you have any questions, sir? All right, thank you.
Thank you, Judge.
You're welcome.
Thank you.
All right, Gustavo Jimenez.
That's all stuff. I don't know who this is. Is that yours? Yeah, that's okay. Oh, you did bring it. You did bring it. You should do that.
You're welcome.
The other one's on.
Just 1 second. All right, who's next?
I have Oscar Naranjo, four down.
All right, Oscar Orozco Navarano. Hello. All right, are there any Spanish-speaking attorneys in the courtroom who are on the will?
Joseph Bateson or Monica Guerrero would be here.
All right, Spanish-speaking attorneys? All right, Norma, we do have a Spanish-speaking attorney in the box.
Good morning. I filed my motion to withdraw.
All right,
Mr. Orozco Naranjo is a Spanish speaker.
all right, we'll need an interpreter here. All right, just have a seat, sir. How do you say in Spanish to take a seat? I'm sorry, what? Thank you. All right, we'll get an interpreter here. Anyone else who's ready?
Yes, ma'am. We have Henry Rodriguez, page 3.
And Norma, if you'll have that attorney on it, please.
Mr. Garza?
Yes.
Hi. I'm
Thank you.
Henry Rodriguez. Hello. So where are we on discovery?
We need to deliver a thumb drive for a number of telephone conversations, Your Honor, to the state.
And is that the only outstanding? Oh, come forward, sir. This is about you. All right.
That's it, Your Honor.
And that's the only discovery that's outstanding?
Yes, Your Honor. Sure.
All right, Ms. Ferguson, if I can have a 30-day reset for discovery, please.
September 30th.
All right, we're going to come back on September 30th and state you'll need to be prepared to tender an offer.
When's the tender done?
Oh, so Norma, September 30th is plea deadline day.
Yes, ma'am.
All right, thank you for addressing appropriate for court, sir. So when you come back on September 30th, you need to let me know whether or not you've reached an agreement with the state. If you have not, your next setting date will be a jury trial date. Do you understand? All right, once you sign the reset form, you're excused. Just have a seat. Your attorney will bring it to you.
Thank you, Your Honor.
Thank you. Anyone else?
Yes, ma'am, we having a fee ready?
Okay. And who is it with?
It's right there, Judge.
Okay.
I'm sorry, I didn't get the name, moving the date.
Oh, no, I see it.
Right here. It's on the first page, second down, Judge. It's Troy.
All right, on Troy Mishler, are you all going to be requesting a PSI? All right, I need a reset date for PSI.
Yes, ma'am, give me 1 second.
Oh, I think someone here can put the offer on the record. I'll walk them through it.
October 13th.
All right, Ms. Mishler, Mr. Mishler. Come forward, please. All right, could a prosecutor take this plea, please? And I'll walk you through the plea. Court is calling 2024 CR 010526-02. Can I have parties announced?
Carissa Chilkowski for Mr. Mishler.
And are you Mr. Mishler?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mishler, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears from the indictment and the plea paperwork, you're proceeding on counts.
Just counts 1 and 10, Your Honor.
All right, thank you.
I apologize.
All right, if we can go off the record for a moment.
Your Honor, just for the record, my name is Andrea Crespo for the state.
I'll have the full indictment, because this only has one count.
Yes, ma'am, I'll go ahead and bring that right now.
All right, so you're proceeding on counts 1 and 10,
Yes, Your Honor.
and how many counts?
There are 10 counts total, Your Honor.
All right,
And so we're proceeding on, yeah, 1 and.
all right, any objection to the waiver of the other counts?
No, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, did you understand in counts 1 and counts 10, you're charged with possession of child pornography younger than 10 years of age and possession of child pornography less than 50 videos. And the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine, and anywhere from 15 years to 99 years or life imprisonment with a possible fine up to $10,000. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
We have, Your Honor.
The indictment being finished right now, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
We do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
And counsel, you want to announce as well?
Sam Locke, with Ms. Chilkowski representing Troy Mishler.
Mr. Mishler, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I'm so sorry.
So this is State's Exhibit 2, Your Honor, with the motion to seal attached. So that was just defense's copy. So this
All right.
is-
Thank you. All right, we can. Let me re-ask that question because the paperwork has been changed. Do you understand that if you were not a citizen, that based upon these charges and entering into a plea of any of these charges, you could be deported, not allowed re-entry into the United States, and denied naturalization? Did you understand?
Yes, ma'am.
All right. All right, everyone, if y'all could stop approaching, we're on the record, and I'm trying to focus on this. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on counts 1 and 10. They're asking that your punishment be assessed at a cap of 30 years in the prison. There's a $5,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? To count 1 in the indictment, how do you plea?
Guilty.
To count 10 in the indictment, how do you plea?
Guilty.
State, any evidence?
Yes, Your Honor. The state moves to admit states exhibits 1 and 2 into evidence.
We've reviewed and have no objections, Your Honor.
All right, and with regards to the seal,
States exhibit 2, Your Honor, it does have a motion and an order to seal on that record regarding the content of.
all right, any objection to the court signing the motion to seal?
No, Your Honor.
All right, the court will find the motion to seal, which is a part of States Exhibits 1, and it's listed as States Exhibit number 2. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty of counts 1 and counts 10. This will be set for a PSI and TAP evaluation on October 13th. Is there anything else?
Nothing from defense, Your Honor.
All right, once you sign the reset form, you are excused after you speak with probation.
Thank you, Your Honor.
You're welcome.
Will be excused?
Yes.
The first bench, sir. Okay.
There's something there that needs to be sealed.
Thank you.
Good day.
You too. All right, anyone else?
Yes, ma'am. We have Jesse Ramos, page 3. Thank you.
All right, Jesse Ramos. Thank you.
Do you need him up here?
Yes.
How are you doing, Judge?
Oh, I'm doing great. How's it going?
Oh, pretty good.
College football season is about to start.
Can't wait.
Cornelius has hopes and dreams. I don't know if, he's looking at them with his heart or with his mind, but
Well, he's going by, I had a conversation with him by how well they finished off last year, even though he had been hurt and then he came back, that quarterback. And I think they won like the remaining games when he played. So
Ah,
he's going by that.
uh,
But he's hoping that if he gets back, and of course Texas plays Ohio State, so
uh, we shall see what will happen.
we find out.
Well, if Daryl is here, you know he loves for you to say the Ohio State Buckeyes. I'm like, yeah,
Okay, okay.
we're not gonna do that though.
Well, everything's kind of like filtering itself out now that with now they're paying some players and stuff like that. So now everything is kind of leveling off. So now we have some real good teams that weren't good before.
Yeah, we'll see what will happen. All right, so where are we on discovery in this case?
Done everything we need, Judge.
Okay, and was an offer tendered?
Yes, it was.
And sir, how old are you?
21.
All right, Ms. Ferguson, on this case, if I can have a 30-day reset for plea deadline date and state, if you could do an acknowledgement for discovery, please.
Yes. September 29th.
All right, we'll be back on September 29th. At that time, you need to let the court know whether or not you've reached an agreement with the state. If you have not, your next setting is going to be a jury trial setting. Do you understand?
Yes, ma'am.
All right, in this court, docket is not at 9 a.m. Why were you late?
I was caught in traffic.
I'm sorry, what?
I was caught in traffic.
So
Downstairs and coming up and all that.
here's the thing. You gotta remember, school is in session. So there are gonna be a lot of people on the road, but everybody is required to be in this court at 9 a.m. Do you understand?
Yes.
So do not be late again, all right? All right, just have a seat and your attorney will bring the reset form to you. All right, thank you.
See you later, Judge.
All right,
Have a good one.
all right, you too.
Thank you.
All right, anyone else?
Yes, ma'am. Richard Campos, page 7, it's down. Yeah, you could-
All right, Richard Campos.
Morning, Judge.
Good morning, how's it going?
It's going all right. It's going all right. Excited about the football season too.
Oh, hey. All right, so Mr. Campos, you've been in this court to know. You can't be late. Do you understand?
I wasn't late. You won't be late again, Judge.
All right. So today is plea deadline date.
We have not reached an agreement. We'll request a jury trial setting, Judge.
All right. And is this criminal trial division or family violence?
CTD.
All right, Ms. Ferguson. Well, let me ask you, do you have the transcript from the co-defendant's trial?
No, Your Honor, we don't need one at this time.
All right. All right, let's go on the record. Court is calling 2024 CR 2339A, State versus Richard Campos. Can I have parties announced for the record for the state?
State.
Brian Oriel from Mr. Campos.
And are you Mr. Campos?
Yes.
All right, so defense, in this case, you say you have all the discovery?
Yes, Your Honor.
Right. And the co-defendant did have a trial, but you're saying you're not requesting transcripts and you do not need transcripts?
No, Your Honor, we were able to actually be able to view the testimony to see if we were going to need it or not. And at this time, we do not.
All right, so you understand, Mr. Campos, that this trial setting, if for some reason your attorney asks for the transcripts and they're not completed by the time the jury trial starts, then you're not going to have the transcripts. All right, Ms. Ferguson, need a jury trial date. How long do y'all expect this trial to last? I'm sorry, how long? 3 days, Ms. Ferguson.
I would agree with that, Judge.
I can do the September 8th.
All right, September 8th.
Okay, Judge.
All right, once you sign the reset form, you're excused.
Yes, ma'am.
Thank you. All right, anyone else?
Andrew?
I'm gonna get on your,
Okay. Who is it?
I have Andrew Reyes.
Page 3, 4 down. Okay, page 3, 4 down. Andrew Reyes. All right, Andrew Reyes. All right, so Norma, since the attorney who's the Spanish speaker has been placed on the case, has he already talked to him?
No, not yet, Judge, because we're waiting for Valentina to step out.
All right, so if you'll let him go ahead and talk to him and then so that at least he can have conversations with him while I do this. All right, on this case,
That's when I put on the list. That's not when I got
all
here.
right, do you have all the discovery? I know there was an issue with cases being moved.
No, Your Honor, that I know, I've got, the paperwork on my client, they uploaded paperwork on a co-defendant, but I have not seen any videos or anything of that nature that I would assume they're gonna be, since there was searches of the house and.
All right, what videos?
Yes, sir. See with the body worn camera that I asked to be submitted and the videos still haven't quite transferred over through their pool, but I will see that that is done.
All right, Ms. Ferguson, I need a 30-day reset for discovery.
September 29th.
All right, this will be the final discovery. So September 29th, we'll come back and make sure that your attorney has everything. Thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you are excused. All right, who's next?
Oh, yeah. I have, did I read this? Are you ready?
Thank you. You're welcome.
There are a lot on me. If I found the which tire. Are they short?
Tony Hernandez.
Thank you.
All right, Ms. Ferguson.
Yes, ma'am.
On Miguel Aguilar on page 8, can you give me a 2-week reset, please? That's the one who you said was being taken to the hospital?
Okay.
At the jail?
Okay. You said 2 weeks?
Yes.
I think it'd be September 8th.
All right. All right.
Yeah. We can do a hospital according to law.
Gotcha. Understandable. September 8th.
Yeah.
Okay, I appreciate it. Thank
You're
you.
welcome.
All right. And then on Oscar Orozco Naranjo. All right, if you guys can come forward, please.
Good morning, Your Honor.
Good morning. All right, the court is going to call 2025 CR 008245 State versus Oscar Orozco Naranjo. Could I have defense announce?
Valentina Kogut on behalf of Oscar Orozco Naranjo.
All right, and we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, Mr. Naranjo, your attorney has filed a motion to withdraw. She believes that you would, it will be easier to communicate if you had someone who spoke Spanish. Is that correct, counsel?
Yes, sir.
All right, do you have any objection to this attorney withdrawing and an attorney be appointed to you who is bilingual?
Your appointment? Okay. Your appointment? No, no, it doesn't.
No.
No.
All right, then your motion to withdraw will be granted. Thank you so much. All right, and then counsel, if you can state your name for the record, please.
Abelardo Garza.
All right, and do you speak Spanish fluently?
Yes, Your Honor.
Right. And are you able to represent Mr. Oscar Orozco Naranjo
Yes, Your Honor.
and Mr. Oscar Naranjo? Do you have any objections to this attorney being appointed to represent you?
Yes. Yes.
All right, this is what I mean. And I'm just going to repeat it because maybe my question wasn't as great as it should be. The previous attorney who was appointed to you did not speak Spanish. This attorney speaks Spanish. So this attorney will be appointed to represent you. Do you understand?
Yes.
All right. Then you'll be representing him. And counsel, do you want a reset?
Yes, Your Honor. I'd like time to look at it. I discussed it with him and I need to look at the discovery and see what's going on.
All right, Ms. Ferguson, if I can have a 30-day reset on this, please. All right, you will be brought back on September 29th. And according to the record, your client does have a hold. All right.
Yeah, I got that. That's the other one. Let's come back tomorrow. Thank you.
Oh.
All right, I'll call DL Ramirez.
No.
And counsel, in this case, are there any applications?
Yes, Your Honor.
Okay.
We're gonna have to reset for a PSI.
All right. All right, so is there an application for community supervision on this case or
Yes.
just deferred?
It's an application for probation, Your Honor. I think they're opposing deferred.
All right, so are they opposed?
Not applying for deferred, yeah.
All right, so on this case, are you all opposed to community supervision? All right, so any objection to the court? Ah, okay, I see how you did it. All right, the court is calling 2025 CR 0086662 State versus Alcadio Ramirez. Can I have parties announced?
Abelardo Garza for the defendant.
All right, and the interpreter has previously been sworn in. But for the record, would you state your name?
Arlene Abrams, license number 2081.
All right, Mr. Ramirez, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
And counsel, do you speak Spanish fluently?
Yes, Your Honor.
And have you been able to communicate with your client in Spanish?
I have, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Ramirez, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes,
Right, you're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
yes,
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, state? The state would call in the right to remain silent?
yes,
Did you understand by entering this plea, you were giving up those rights?
right,
And did you intend to give up those rights and enter into a plea in this case?
that's right, yes,
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
right,
Did you understand if you're not a US citizen, by entering a plea in this case, you could be deported, not allowed re-entry into the United States, and denied naturalization? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 5 years in the prison. There's $1,000 fine. The state is opposed to your application for community supervision. Did you understand that to be the plea?
okay,
No, did you understand that to be your plea bargain agreement?
yes,
Defense, is that the plea?
That is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No, Your Honor, there have not.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest,
State, any evidence?
Yes, Your Honor, state offer states exhibit 1 in all attachments.
No objections, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
yes,
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes,
All right, and state, you may be excused. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Ms. Ferguson, I need a date for PSI.
I can do
And
that.
I'm so sorry. How did he plead?
No contest.
Thank you. Yes.
October 13th.
All right, we're gonna come back for October 13th for sentencing. I'll request a PSI and TAP evaluation. I'll base my decision on your application based upon any evidence that's presented to the court. All right.
You can just write it on.
Yeah, approach your honor.
Yes,
Now be excused, Your Honor.
yes. And I don't know, probation may need you.
Oh, okay.
All right, thank you. No, I'm forgetting to be.
Okay.
Yes,
Valuation on that one as well?
yes. All right, who's next?
So I have John Rosary on page 9.
John Barry.
Present, Your Honor.
All right, so what are we here for? Is this for a motion?
This is a motion to revoke probation, Your Honor. My client does intend to plead true.
All right, could I have the motion to revoke probation on this case, please?
What is this?
It's John Barry on page 9.
What are we doing?
Yes.
So sorry, Judge, I was not ready.
No problem.
I don't even know if they did a search.
Okay. Renee, did you do a certification on this?
Oh, Your Honor, you know what? My apologies.
All right.
We forget to do that, one
That's what it
portion.
was, just we didn't have it ready because we didn't have the search.
Okay.
I do apologize, Your Honor.
Oh, hey, it happens. It's a Monday.
Manic Mondays, so they say.
I just sat on the back real quick, just to get everything okay.
All right, thank you.
Diana, can you give me that clause number for John Barry?
Yes, that's 2025 CR.
Okay.
01
Okay.
2861.
Thank you so much.
Yeah.
All right, court is calling 2024 CR 012861 State versus John Barry. Can I have parties announced?
Lauren Espinoza for the state.
Renee Munoz on behalf of Mr. John Barry.
And are you Mr. Barry?
Yes, ma'am.
All right, did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same John Cowan Barry Jr. who's placed on community supervision in 2024 CR 012861 for the offense of evading arrest detention with a previous conviction on February 27, 2025 for a term of 4 years?
Yes.
All right, state.
Yes, Your Honor, state is proceeding on violated condition number 41, which states on or about the 29th day of July, 2025. In Bexar County, Texas, the defendant, John Cohen Berry Jr., did then and there fail to comply with the rules and regulations of the felony drug court in violation of Commission 41.
How do you plead to that, true or not true? And state, are you waiving the other allegations?
No objection from the defense.
All right, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes, no.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes,
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 2 years, as well as take into consideration clause number 2025 PF 29310.
Your Honor, we would just ask if we can just be heard in terms of the time of confinement with certain justifications related to substance use disorder.
All right, and the case that you're asking to be taken in consideration, what were the last 4 digits again?
29310.
And what is that offense?
That is possession of controlled substance, PG1.
All right. So are you in agreement with revocation?
Yes, Your Honor.
Okay. And then the court then will hear your argument with regards to sentencing.
Thank you, Your Honor. Concerns of the punishment to be assessed by the court. We asked the court to take judicial notice on the court summary provided by probation that he did successfully complete lifetime recovery inpatient for the dates of March 14th, 2025 through June 30th, 2025, which he was issued a certificate of completion for that inpatient lifetime recovery. We do know, and we are aware that the court knows that he was subject to felony drug court conditions. He did suffer a relapse in which he self-admitted to felony drug court that he was using substances. So there's no dishonesty behind his issues, Judge. He did kind of fall off. He was at a sober living home, and then he did abscond from there upon relapsing. He did state reasons for doing so, where he was trying to get back to his family members that live in New Mexico. He did state that his grandmother is suffering from cancer, lung cancer. It's very serious, as well as mother that has diabetes. So there needs some help. We do believe that since Mr. Barry is not from here, San Antonio, he didn't have the proper support system. So that's why I think he's proceeding with this route, trying to resolve these issues, to get back to his family, to provide the support that they're needing, Judge. He hasn't been to state jail before, and this is my understanding is an abating arrest seconds underlying offense. So we asked the courts to weigh all those factors and announce the punishment. We were asking for less than the 2, Judge. We'd be asking for 10 months in a state jail facility based upon his issues with substance use. The fact that he picked up a new case is this possession case, nothing violent, and doesn't have a violent history, Your Honor. For those aforementioned reasons, we're requesting less than the 2 years.
All right. So the court is aware that this is a evading with on foot. It's not in a vehicle. But also the court is noting that you absconded. That's a problem. And with felony drug court, I know that if you tell them what your issues are, they would have made arrangements with regards to any health issues your relatives may be having. Court is going to grant the motion, sentence you to 18 months in the state jail facility, give you credit for any time served, taking consideration 2025 PF 29310, and the court will give you credit for any successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that means, you'll need to speak to an attorney. Do you understand? And I'll also request the therapeutic community. I have no authority to force them to place you in the program. I can't order that, but they'll see that it's in the judgment that you need help with any type of drug addictions. It does not increase the length of time that you're in custody. It's just to help you with your addictions.
Your Honor, would the court consider presumptively granting him diligent participation credit upon him doing substance use classes, vocational and educational training in the state jail facility?
I will consider that once I receive it.
Yes, Your Honor.
Right. All right, so here's the thing, when you're released from custody, if you truly want help with your drug or alcohol problem, if I'm still here when you get out, I'll help you find a sober living house. But at the end of the day, if you continue the path on that, you're only one of two things going to happen. Either you're going to end up in somebody's prison or jail for the rest of your life, or either somebody's going to be identifying your body because the last time you use may be the last time you use. You understand? All right, good luck to you. So legally, I must give people credit for successful completion of inpatient treatment. So there's no way I can say, oh, I'm not going to give you credit for that. Now, sometimes there's a question over what successful completion means. Yes. Anyone else ready?
Yes, ma'am. Page 1, 7 down, Marcus Butler.
Yes. I take a lot of things in consideration. The fact that he was arrested for a new charge, but then at the same point, it's a drug charge. So, and he's addicted to drugs. The fact that he absconded from felony drug court, which they're trying to help you. So it's a lot of factors to consider. All right, who did you say, Norma?
Marcus Butler, page 1, 7 down.
All right, Marcus Butler.
Here you are.
Hello, Mr. Butler. Thank you for dressing appropriately for court. All right, so they have you, are you retained on this case?
No, Your Honor, I was appointed in April.
Yes, that's why they have that here. Norma, can you make sure that's corrected?
Yes, ma'am.
All right. So, were you able to open videos and all of that?
Yes, sir, and respectfully, I've gone over all the evidence with Mr. Butler. I'm gonna fall on the sword. One of the issues that when I was going through all the videos and everything else, there may be a legal issue. And I know this is a plea deadline date, but I'm asking the court if I got a little more time to look into that issue. Once I've done that, I think we'll make our decision.
All right, Ms. Ferguson.
Yes, ma'am.
On this case, I'm going to put your jury trial date the same date as your plea deadline date. If you want to come in before then, if y'all have reached an agreement, he can always put that on the docket before then. So how long do you expect this trial to last?
Maybe 2-3 days.
All right. So would he want a bench trial or a jury trial?
A jury.
All right. Ms. Ferguson, drug case 2 days.
Yes, ma'am.
Actually, he has 2 cases, Judge, 2 different indictments.
Okay.
I can do the
What by count?
Okay.
October 28th.
October 28th?
Yeah.
All right. So your jury trial date and plea deadline date is going to be October 28th. Once you sign the reset form, you are excused. All right, thank you. All right, anyone else?
We'll say Giannis on page 7, 4 down.
Jose Yanis. Good morning.
Morning.
Thank you for dressing appropriately for court. Let me see, it's saying no match found. All right, where are we on discovery?
We've received the appropriate discovery judge since our last setting. This was a discovery.
Just to make
compliance setting.
sure. So you have all the discovery.
I do. I've learned a lot about this case.
All right, so state, I'll need an acknowledgement of discovery. Was the state able to tender an offer?
They were able to tender an offer today, regard for a plea, 4 year
Oh,
deferral.
no, I don't need to know what the offer is. I'm not supposed to know.
Okay.
All right, Ms. Ferguson. Can I have a 2-week reset for a plea debt, well, 3-week reset for a plea deadline date, please?
The paperwork with you.
Well, I did start filling it out because you asked me to, but we're fine coming back for that.
Jill, well, why am I calling the case then?
Because you wanted to ask for more time.
Oh, no.
We were gonna have.
I wanted a plea reset.
Oh, no. That will be done today.
We want to do a plea today.
Yes.
Okay.
All right, thank you.
Can we do the plea reset? Can we do that? Can we
No,
do
I
that?
mean, we're gonna take his plea today.
All right.
All right, thank you.
Thank you.
All right, anyone else?
Yes, sir. Page 9, 5 down. It's Young. And this is, he's only got some. He's out for the meeting.
All right. All right, Austin Young. All right, so my understanding,
Oh, he's in trial, Judge.
all right,
Disregard.
your attorney is in jury trial.
Yes.
So we're gonna reset you in 3 weeks. Let me see. Why is this pulling up as no? Let me see. Okay, this case number is not pulling up for me.
It has a W, Judge, at the end.
No, I put the W in. Let me see, maybe cross my fingers.
Not to put DC.
All right. Norma, set this in state. Will you be ready in 2 weeks for, is this going to be a contested hearing or something?
I think it is.
I have it down as a contest.
All right, Norma, if you'll set this in 2 weeks for a contested hearing, it's Austin Young. Will you state, will you be ready?
I believe we'd be ready 2 weeks, Judge.
All right.
Sure about that. We don't want everything.
September 11th.
All right, September 11th. Once you sign the reset form, you're excused, and thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome.
Here you go, Mr. Young.
Sure.
You have it inside.
I've signed up on the.
All right, who's ready?
It would be page 4, 3 down, Brandon.
Brandon
I cannot pronounce that last name, Judge.
Caskell.
Caskell.
Good morning.
I know.
Brandon.
Hold on, this is about him. All right, so let me see on here.
We're having, we have an offer now. We're asking for one reset and we're gonna come back and I believe accept the offer at the next reset.
All right, how much time are you asking?
30 days,
All right, Ms. Ferguson.
maybe 40.
All right, Ms. Ferguson, if I can have a 30-day reset.
I can do September 30th.
All right, September
I'm
30th.
out of town that week. Can we come back to can we come the week of October 6th, if we can?
All right, Ms. Ferguson, the week of October
I
6th.
can do October 6th.
Okay,
All right, so here's the thing. Court starts in here at 9 a.m. You need to be on time at 9 a.m.
Yes.
You understand? All right, Norma, if you're given the reset form, once you sign that, you're excused.
thank you, Judge.
You're welcome.
Here, Brandon.
So much.
You're
Give
welcome.
me your auditor.
All right, is there anyone who's ready right now? All right, after this, we're taking our recess.
Thank you. Thank you, Judge.
You're welcome. Kelly O'Gara, who's the attorney? All right,
That is the, so he's not far.
he's not far, yeah. He wouldn't leave that behind.
Can you do another one, Judge? Can you
just
do a
walked in.
reset for someone that didn't show up?
Who didn't show up?
Jeremy, is it Jeremy?
It's you there. Yes, it's fine.
All right,
I'm looking for the page, Judge.
all right, just give me, let me do this and then I'll take that.
Oh, I didn't see Cornelius.
Yes.
Yes, sir. All right.
Hello.
We're looking, Judge, right?
They said they knew you had not left because you left behind your cap.
My cat, I can't get far without.
All right, are these applications?
Yes, Your Honor.
And is there gonna be sentencing today? Or is it
I think, well, it's a, I think.
It's a recommendation?
Correct.
All right, the court is calling 2025 CR 0075662B and 2025 CR 009816 State versus Kelly Aguero. Could I have parties announced?
Jason Garrett for the state, Your Honor. And Bernard for the state as well.
It's Scott's for the defense.
All right, so off the record for a moment. So they don't have the W to signify waiver numbers anymore?
The clerk informed me at the last setting we did this, but they don't do that.
Okay,
Unfortunately.
all right, just so I can know where we are. All right, we're back on the record. And cause number ending in 16, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.05 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
And did you understand that?
Yes, ma'am.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial? Your attorney has certain rights. Also, the right for the passage of 2 days once he's presented with the information and 10 days to prepare for trial. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
In that cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Miss, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the court admonishments in each of these, state?
Yes, Your
Just one moment. I'm just trying to find a document. All right, we're off the record. Defense, did you all get a copy of the information?
Yes, Your Honor. I think
All right, to
Gave
the
it
clerk,
to
so
the
I don't have a
clerk.
copy of the information.
She stepped out, Judge.
well, I don't think this is the original. I thought I gave them the
Could I
copy.
see that and I'll hand it back
Yes,
to
ma'am.
you. All right, we're back on the record. Did you review the information in the cause number ending in 16 with your attorney? Did you understand it? Counsel, do you waive the reading of the information?
Yes, Your Honor.
And state you're proceeding on the information as presented?
Yes, Your Honor.
All right, and then in cause number ending in 62B, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, no objection.
And each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 16, you're charged with placing a child in imminent danger of physical and mental impairment by having child in an environment with access to illegal substances. PR counsel, that's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court can find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 62B, you're charged with possession of a controlled substance penalty group 2, 4 to 400 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison with up to a $10,000 fine. If for any reason the court were to grant your application for deferred adjudication, if for any reason that deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand? And each cause number, if you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into this pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Aguirre, on each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes, sir.
Did you understand if you're not a United States citizen, then you could be deported, denied naturalization, and not allowed re-entry into the United States by entering into this agreement? Did you understand?
Yes, sir.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the cause numbers, in one, your fine is $2,000. The other is $1,500. The cases will run concurrently. And there is to be a recommendation of deferred adjudication, and there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea in each of these cause numbers?
Yes, sir.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
So, Your Honor.
Outside the agreement in the drug case, the state is requesting that your term be for 6 years. There'll be a TAP evaluation, 200 hours community service restitution, parenting classes. In the state jail felony cases, the state is requesting that your community supervision be for 2 years, 100 hours community service restitution, no contact with Layla Aguero, parenting classes, TAP evaluation, and follow all recommendations in the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
All right, then, and
Here's a minor that was done, I guess, after here from the paperwork. As far as the no contact, where the agreement is now, because this was, I guess, continued from the last setting for CPS record purposes, for us to do other than and determine what happened at the CPS hearing. So to make it easy, we are agreeing with defense that she can have contact with the children, but there just be monthly field visits for the entire 2 years of the perjury case. And so
why did y'all ask probation if they want to do monthly field visits?
I did, and it was indicated to me that that would be something they could.
All right. So they're asking then for no harmful or injurious contact with Layla Aguero. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? All right, then in cause number 2025 CR 0056, I'm sorry, 7526B, how do you plead to count 2?
No contest.
And cause number 2025 CR 009816, how do you plead?
No contest.
State any evidence.
Regarding both cases, Your Honor, state off proven the evidence cases, one, those have things.
No objection.
In each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication in each of the cause numbers. So when is the co-defendant scheduled in this case for sentencing?
Tomorrow. For the other one, for some of this one, we got reset for a week.
No, I mean, the one that, so this is a case where Suzanne Kramer is the defense attorney.
That one's tomorrow.
Tomorrow. All right, counsel, are you able to come back tomorrow?
I can, Judge. What happened, if the court recalls, originally I wanted it for that same day.
Mhm.
But I guess it wasn't possible when we reset it.
Okay.
But if I need to come back, Judge, I'll come back.
All right, if y'all can come back, and what I can tell you, this is what I'm going to request. See if the CPS caseworker can zoom in so the court can see what's going on.
I think they keep the state can
Have
make
those,
a profit, Judge, that they completed everything.
here's the thing, in some situations, I don't like proffers because people need to be on the record for what they have done.
Oh.
Yeah, so,
See if we can get the CPS.
all right, and they can appear by Zoom.
Okay, that's fine.
All right, so we'll bring you back tomorrow for sentencing. And
Okay.
sentencing will happen on that day, all right?
All right.
Once
Thank
you
you.
sign the reset form, you're excused.
Thank you.
You're welcome. All right, and Brenda, who's your person?
I had a hearing ticket.
Let me see what page he is on.
He's on page 9, 6 down.
Your Honor, he was a hired client on NTR. We had contacted the family yesterday, and we can't get a hold of him today. We are on the bond. We're asking the court to increase bond.
All right. Court is calling 2022 CR 3839 State versus Jeremy Joseph Duke or Duque. Could I have parties announced?
Brandon Lopez from Mr. Duque.
All right, this hearing was scheduled at 9 a.m. It is now 12 p.m. Counsel, have you had any contact with your client?
We have not today, Your Honor. Yesterday, we had contact with him and his family, and nobody's been able to get in touch with him this morning. So we're trying to figure out what happened.
All right, Deputy, did you make an announcement?
Yes, sir.
And what are the results? All right, State, what is your request?
We'd ask that you increase bond and issue one.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
You're welcome. All right, the court is taking its recess.
Lana, do we have a Rodriguez here in the?
Oh, no show means that they didn't show up for court and they're supposed to be in court, so sometimes they're bond. And a bondsman has said they will appear, and if they don't appear, then you can issue a bond forfeiture. So for example, let's say somebody's bond is $20,000. Well, people don't have $20,000 laying around, so usually they go to a bondsman, and a bondsman will give them our 10%. And they're supposed to appear. So if they don't appear, then that bondsman is on the hook for $20,000. So sometimes attorneys will say, "You please do a bond increase." Like in this case, the reason why I do a judge's warrant is because it's a motion to revoke. Where the judge, when they see that my judge, nobody will give a bond. Okay.
That hearing had a little bit of everything. Judge Boyd ran a tight but balanced docket, moving from discovery resets to full plea colloquies without ever losing her calm tone or her patience, which got tested here and there. She has a way of keeping the courtroom orderly while also sprinkling in just enough casual conversation to remind everyone this is a human process, not just a conveyor belt of cases. At one point, the courtroom even drifted into a light debate over college football hopes, which was probably the least expected tangent in a morning otherwise full of procedural checklists and rights advisements. Judge Boyd let it breathe for a moment, then gently reeled everyone back to business, proving she knows how to manage both the docket and the personalities in front of her. Defendants varied widely in demeanor. Some, like Henry Rodriguez and Jesse Ramos, were polite, attentive, and appropriately dressed, taking in every instruction. Others needed reminders. One gentleman blamed traffic for being late, and Judge Boyd didn't let that slide. She reminded him school is back in session, so he better plan accordingly. It wasn't harsh, but it was firm, the kind of accountability that makes expectations crystal clear. On the more serious end, defendants like Troy Mishler and Alcadio Ramirez entered pleas to significant charges, and Judge Boyd meticulously walked them through each right they were waiving, double-checking they understood the consequences. Mishler, in particular, faced very steep sentencing ranges, and the judge's tone shifted into a more formal register during his colloquy, leaving no doubt about the gravity of his plea. Attorneys were generally professional, though a few were caught slightly off guard when paperwork or exhibits weren't ready at the exact moment they were called. In one case, the prosecutor realized midstream that the indictment pages didn't line up, and Judge Boyd gave them space to straighten it out without embarrassment. Defense counsel, for their part, often requested resets for discovery or for plea negotiations, and while those requests were granted, the judge repeatedly reminded everyone that deadlines are real and that jury trial dates are not just placeholders. She wasn't scolding, just emphasizing that the calendar moves forward whether people are ready or not. One of the more interesting moments came with Oscar Orozco Noronha, where a language barrier prompted a motion to withdraw by his first attorney. Judge Boyd ensured he got a bilingual lawyer, and she used an interpreter to confirm directly with him that he understood the change. It was a thoughtful handling, efficient, but also careful to make sure the defendant wasn't left in the dark. In another matter, John Barry admitted a probation violation. The judge balanced his relapse and family concerns against the fact that he absconded from drug court, ultimately giving him 18 months but credit for inpatient treatment he had completed. Her closing words to him, warning that the path he was on could only end in state custody or worse, were sobering, delivered more like a concerned mentor than a stern disciplinarian. The overall atmosphere of the courtroom was steady and respectful, with occasional moments of levity cutting through the formality. From football chatter to small acknowledgments of defendants dressing appropriately, there was a sense that Judge Boyd sees each person in front of her as an individual, even while handling a very full docket. No chaos, no grandstanding, just a well-run court balancing efficiency with fairness. By the end, it was clear. Everyone had their marching orders, deadlines were set, and the judge had once again managed to blend firmness with humanity in a room full of very different cases. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know